So a new case challenging a state's ban on so-called assault weapons is now in front of the Supreme Court, and this one is going to be hard for the Supreme Court to avoid. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. Not only do they have amazing supplements, I use their protein shake all the time, but also they are pro-freedom and pro-Second Amendment. So if you want to get amazing supplements and support a great company, check out 1st Phorm using the links down below. And thank you again to 1st Phorm for sponsoring and supporting this content. Now, as I mentioned in the intro, in this video, we're going to be talking about a new case that has now been submitted to the Supreme Court for their review. And this comes on the heels of a recent decision by the 4th Circuit en banc panel, which now is likely going to force the hand of the Supreme Court to have to review a ban on so-called assault weapons. In this video, we're going to be breaking down and discussing the Maryland assault weapon ban case Bianchi versus Brown. And this is a case that we've talked about before, but now because of a recent 4th Circuit en banc panel decision and what they decided in that case, and this being a final merits decision, this has now been filed for a writ of cert to the Supreme Court, and it's the exact type of case that the Supreme Court said that if they had presented to them, they would have to address. Now, recently, the 4th Circuit en banc panel stuck to their position that semi-automatic rifles, like the AR-15, are in fact useful in military service, and as militaristic weapons, they can be regulated by a state like Maryland, since according to the state and the 4th Circuit, these are dangerous and unusual weapons. And now this case has been submitted to the Supreme Court, and this is one of those cases that's going to be very hard for the Supreme Court to avoid. Of course, the Supreme Court does not have to grant review to any case, but the Supreme Court has stated multiple times that they know they have to address the issue of bans on so-called assault weapons. They have to address rifle bans and probably even magazine bans as well. Recently, when Judge Thomas and the other judges denied review to the Illinois cases, Justice Thomas actually had a statement in that saying that he knows they have to address this issue of rifle bans, but that they wanted a final merits case. And this Bianchi case has now been submitted to the Supreme Court as a final merits decision on an issue about a state banning outright the possession and use of so-called assault weapons. Now, for those not aware, the state of Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, and possession of semi-automatic centerfire rifles with detachable magazines and two offending features like folding stocks, flash suppressors, and other accessories as well. And in the original lawsuit, the plaintiffs had to concede that their Second Amendment claims were not really allowed because essentially there was precedent in the 4th Circuit because of a case called Colby. And in that Colby case, there was already a challenge to the Maryland ban on so-called assault weapons. Now, in that Colby case, an en banc panel in the 4th Circuit upheld the Maryland rifle ban, essentially finding that these were useful military service, that these were militaristic weapons, and because of that, they could be banned. And also they used intermediate scrutiny to uphold the Maryland ban. This case, Bianchi conceded that Colby is the controlling precedent, but that they believed that was incorrect and should be reversed. However, the district court in the Bianchi case ultimately had to dismiss the complaint for a failure to state a claim because of what happened prior in Colby. Now, that dismissal was then appealed to the 4th Circuit, and the 4th Circuit once again upheld that dismissal, saying, hey, we can't review this because of our prior precedent in Colby. Well, then this case went to the Supreme Court back in 2022, and it was seeking review on this very issue. But the Supreme Court was set to rule in the Bruin decision. They did issue their Bruin decision. That was a 6-3 decision, and they once again got rid of means and scrutiny. They got rid of the two-step approach, and they affirmed text as informed by relevant history and tradition is the proper analysis. What ended up happening in this case, Bianchi, is the Supreme Court granted, vacated, and remanded the Bianchi case back down to the 4th Circuit for a new review of the case in light of what they just said in Bruin. Now, after issuing that GVR, this case sat in the 4th Circuit for a really long time. A 3-judge panel in the 4th Circuit was set to rule in this case, but then it sat for 13 months. And then after 13 months, the 4th Circuit en banc panel took control of this case and said that they were going to review and rule on this issue on their own. Now, while the 4th Circuit en banc panel was reviewing this case, the plaintiffs here, SAF and some of the other plaintiffs, then tried to kind of jump the system. They went to the Supreme Court immediately on a writ of cert before judgment. Essentially what that is they wanted the Supreme Court to step in early and review this issue before the 4th Circuit en banc panel had a chance to review and decide this case. Essentially, there was discussion about how we all knew that the Fourth Circuit en banc panel was not going to rule in our favor. They were not going to uphold the Second Amendment. They were not going to properly apply the correct analysis. And so it was better to just bypass that and go to the Supreme Court immediately. But at that time, the Supreme Court denied review because what they essentially were signaling is they wanted the Fourth Circuit en banc panel to have the chance to review and decide this case. And as I mentioned, the Fourth Circuit en banc panel has now decided this case, and they sided with the state of Maryland once again, upholding this rifle ban. In that decision by the Fourth Circuit en banc panel, again, they relied heavily on the military use test. They said that these types of rifles are militaristic, and since they are militaristic in nature, they are dangerous and unusual weapons, and they can be outright banned by the state of Maryland. So they stayed very true to what they said prior. They said that Bruen in no way changed this analysis. They argued that Bruen's denial of the two-step approach really didn't impact this case at all, didn't impact Colby at all, because there was history and analogs that supported this type of outright ban on so-called dangerous and unusual weapons. In that decision, the Fourth Circuit en banc panel stated that the assault weapons at issue fall outside the ambit of protection offered by the Second Amendment because, in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. The Maryland law fits comfortably within our nation's tradition of firearms regulations. It is but another example of a state regulating excessively dangerous weapons once their incompatibility with a lawful and safe society becomes apparent, while nonetheless preserving avenues for armed self-defense. They also argue in their decision that the Bruen analysis does not disrupt Colby at all. They also, in their decision, go on a long political rant about how dangerous AR-15s are and how they, are a severe risk to the public at large. And because of that, they are dangerous and unusual weapons, and a state can just outright ban them as dangerous and unusual items. Now, there was also 5 dissenting judges here, so it wasn't like the whole Fourth Circuit en banc panel agreed with this. They stated here in their dissent that after the Supreme Court decided the New York State Rifle and Pistol Association versus Bruen case, it remanded this case for us to determine whether Maryland's assault weapons ban violates the Second Amendment. Rather than considering the amendment's plain text, the majority sidesteps it altogether and concocts a threshold inquiry divorced from the right's historic scope. To make matters worse, it then misconstrues the nature of the banned weapons to demean their lawful functions and exaggerate their unlawful uses. Finally, to top it all off, the majority cherry picks various regulations from the historical record and pigeonholes them into its preferred yet implausible reading of our nation's historical tradition of firearms regulations. And based on that, you had a bunch of dissents out of the Fourth Circuit, essentially calling out their colleagues for not faithfully applying Bruen, not faithfully applying the Second Amendment, and essentially just reaching the decision that they wanted. And because of that, that has now led the plaintiffs here to file a writ assert to the Supreme Court. This is a final merits decision. This is a final decision of the Fourth Circuit en banc panel. And now there is a request for the Supreme Court to review that final decision. And that is huge because last term, when the Supreme Court denied review to the Bianchi case and then also all the Illinois cases, the Supreme Court, and through Justice Thomas in his statement, said that all they wanted was a final merits decision. Now, of course, most of the time they also want circuit splits, but a lot of the statement from Justice Thomas was saying that they didn't want to deal with interlocutory, intermediate, middle cases. They wanted a final merits decision, and this Bianchi case is exactly that. So now the plaintiffs here have submitted a writ assert to the Supreme Court, and so that means during this next term, there's going to be briefing on this issue. Probably towards the tail end of the term. Maybe also it's going to be scheduled for oral arguments. We're going to have those oral arguments and then maybe even a decision if the Supreme Court grants review to this issue. Because remember, the Supreme Court does not have to grant review to any cases. So they can avoid this if they want, but that's really not a really good look for them because you've had multiple statements multiple times from varying justices about, hey, all we want is a final merits decision. We just need something like that to review this issue. We know it's time to review this issue. Well, now they have the perfect case in Bianchi teed up for their review. So for them to now skirt it all of a sudden would be a clear signal that they're probably not going to grant review to any big 2A cases going forward. So the Bianchi case has now been submitted for Supreme Court review, and we will wait to see what happens and develops during the next term. And as things develop, as things change, I will let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.